Welcome everyone who's already here. We're waiting just a few minutes for more people to join us, and then we'll start. So, welcome everyone, and thank you very much for joining this webinar on the basics of IP. Before we start, I would first like to introduce ourselves and Novigraph. I am Noe Himmelreich. I did a master's degree in IP law in Utrecht, the Netherlands. I live in Amsterdam, and after my studies, after my master's degree, I started working at Novigraph as a junior associate IP consultant. And now I'm also in my vocation studies. Next to me is Niels.
Yes, thank you all for joining in today. I am Niels van der Lee. I also work at Novigraph as an associate IP consultant for 2.5 years now. We're established here in Amsterdam, which is also where I live. And I'm also training to be a certified trademark and design attorney in Benelux. And if all goes well, I will be graduated this January.
Well, first off, for the people who don't know Novigraph, Novigraph advise, maintain, and enforce IP rights for companies. And today, from our knowledge in IP, we will try to learn something, well, to give you something of these basics of IP, and hopefully you'll learn something about copyright, which is about creative works, about design, which speaks, of course, for itself, patents for technical products, domains on the internet, trademarks, of course, which is, I think, well known for most people, slogans, which is not a IP right in itself, but still a topic of interest for most people and companies. And lastly, we will discuss trade names. But for now, first, let's take a step back and answer the question: what is IP and why does IP exist? And that's because trade and commerce are free, but to promote innovation, there are certain exclusive rights which form an exception to the free trade principles. But also think of other rules like competition law, but well, for us the most important exclusive rights are intellectual property rights, and well, these exceptions give a kind of reasonable monopoly to the holder of those rights. And these examples are listed below. There are more, but these are the ones we will be discussing today. And let's start with copyright.
Yes, I will start off with the first IP of the day, the copyright. Copyright is a temporary exclusive right on a creative work, and this must be a tangible creation. This also includes any creation or work that has been put down on paper and which can be executed from there, as long as it's still in somebody's head and not have been executed at some form. It cannot be protected as a copyright, of course. A work is very broadly interpreted. The most common works that can be copyright protected are books, films, music, plays, pieces of art, but it can be very broad, as I just said. The criteria for protection is harmonized within the EU, because a work must be the author's own intellectual creation. That may be a little bit of a vague definition. In my opinion, in the Netherlands we have a more clear definition, because we talk about the work must be own individual character, which means that the work is not derived from other existing works or protected copyright works, and the work must have the personal stamp of the creator, and that means that the creator makes creative choices by creating his work. A concept or an idea cannot be protected through copyright, neither as a style or a trend, and it is because those concepts or ideas are too vague, too broad to be protected as such. So only the specific execution of a concept or idea can be protected through copyright. So what can you do with your copyright? The creator of a copyright protected work enjoys the exclusive right to reproduce and publish that work. And then you can, of course, prevent others from exploiting your copyrighted work, and reproduce and publish that. Also, if they are using or exploiting a work that implies the same uh, overall impression of your copyrighted work. In most countries, a copyright arises automatically. So if you have created your work, you have also created your copyright. And there are no registration requirements, but in some countries it is possible. For example, in China or the United States. And this also brings some advantages there, to register your copyright, because especially in the enforcement of your copyright, for example, you can claim damages when you have a registered copyright in the United States, because if you do not have a registered copyright, you cannot do so. The C in a circle is often used by people online, but especially in Europe, this has no legal status. In the US, it can mean that they have a registered copyright, but it does not count for Europe. The duration of copyright varies for different territories and different kind of works, between 50 to 100 years after the death of the author. And that depends on the country, as I just said, and the kind of work. In the Netherlands, in the UK, and the US, it is 70 years after the death of the individual author. And there are no use requirements for your copyright. So if you are not using or exploiting your own copyright, you can still prevent others from doing so.
Well, then you'll learn something about designs. And a design is the new appearance of a product or a drawing or parts thereof. So, for example, see the Louis Vuitton handbag as a product, or the Louis Vuitton pattern as a drawing. And for a design to be legitimate, it needs to meet two requirements, which are novelty and individual character, which I will explain later on. And it's good to understand that excluded from design right protection are technical elements, because these elements should be protected under patent law. and on the other side, invisible elements, when normally using the products, are also excluded from protection. Yes. Well, design is the appearance of the whole or a part of a product, resulting from the features of the lines, contours, colors, shape, texture, materials of the product itself, or its ornamentation, which means that this is broad. This is a non-limited scope, and a product is an industrial or handicraft item, so it's really also a very broad term. Do not only think of design as the expensive goods, but everything can be designed if it meets the requirements of novelty and individual character. Well, the first requirement of novelty means that no identical design may be disclosed to the public before the filing date of your own design or the priority date of your own design. And as an identical design is meant also designs which differ only in unimportant details, and disclosed to the public must also be interpreted very broadly. So it's not a publication in a magazine or on your website. It's everything that's available to the public. And well, the priority date, which is mentioned in the third bullet point, means that when you disclose a new design to the public, you have a 12-month grace period to register a design. And if you fail to do so, your own publication can mean that you do not meet the requirement of novelty. But assuming that you do meet this requirement, you need also to meet the second requirement of individual character, which means that the overall impression must differ from previous designs, and this overall impression is assessed by the informed user. This user is able to see differences between relevant designs, so he holds them really next to each other, and he is more attentive than the average consumer in trademark law, but less attentive than the one in patent law. Lastly, the degree of freedom of the designer must be taken into account, which means that if there are many technical features on a product, but there is some room for design, but the room is very small, that really small changes can mean that the overall impression will differ from the previous design, and also this goes vice versa. So when you have a legitimate design right, then you have the possibility to prohibit third parties to use products in which the design is incorporated or in which the design is applied. And use, again, is a very broad term, which also means importing, stocking, offering for sale, delivering. So protection under design law and with the design registration is very useful to scare away the competition. And how do you obtain this design right? Well, first, you need to assess whether you meet the requirements, so novelty and individual character. And then you need to obtain a trademark registration. And this goes per country or jurisdiction. And it's good to understand that authorities do not check the requirements of novelty and individual character, but only the formalities. So whether the registration constitutes legitimate design right may only be determined in conflict with third parties or ultimately in court. Also, in the European Union, there is a unregistered EU design right. This also exists in the UK, but these have a limited scope of protection and duration. So this is only for really counterfeit products, and the duration is only 3 years after publication, and I believe in the UK 5 years. So as mentioned, a design right registration has a duration of 3 years when it is an unregistered EU design. Sorry for confusion. And it has a maximum duration of 25 years when you registered the design. So every 5 years you need to pay for a renewal to maintain it. And so it may also lapse when you fail to pay this renewal on time, or when the term of validity expires, the maximum of 25 years. It also lapses when you voluntarily cancel it, or after a successful objection by a third party on the requirements of novelty and individual character. And also, just as with copyright, there is no use requirement, so you may always enforce your design right even if you do not use it.
Yes, the next IP we'll talk about is the patent. A patent is an exclusive right granted for an invention, which is a product or a process that provides a new way of doing something or offers a new technical solution to a problem. There are certain findings that cannot be patented, so no right is granted. Discoveries and mathematical methods and scientific theories. The idea behind this is that those should be freely used by anyone, so it cannot be monopolized. And aesthetic designs also cannot be patented, as they can be protected through a design right. The requirements for a patent, there are three main requirements, namely novelty. The invention or process cannot be made public anywhere in the world prior to the date of the application of the patent. So if somewhere in China or Australia or anywhere in the world the invention has been made public in any form, then you cannot acquire a patent registration. The invention must be an inventive step. The invention or process must be an inventive solution, and it may not be obvious from the current prior art. And that means that with the current status of information and tools that are available for the technical experts in that specific field, it may not be obvious that this invention is the next step. And the invention or process must be industrial applicable, which means that it must actually be capable of being made or executed. The duration of a patent is in most territories 20 years, but they made an exception for the pharma industry. They can have an additional 6 years, and that is because inventing and producing medicine is very time consuming, very expensive. So when you have invented a new medicine, you have 6 additional years to recoup your investment. It's also in most countries you have to pay annuity or renewal fees to maintain your patent registration. And also with a patent, there are no use requirements, so you can also just have it have others prohibit the use of your invention or process without even exploring it yourself. And the patent registration will lapse after the term of validity, after 20 or 26 years, or if you have not paid your annuity or renewal fees, you can voluntarily cancel your own patent registration, and it will lapse after a successful objection by a third party. Then I will also talk about the domain names. A domain name is just an address on the internet. It consists of a name and an extension like .org, .nl, .com, .uk. There are many possibilities there. And there is a first come, first served policy when it comes to registering domain names. And a domain name can only be issued once. And that means that if you are the first one to register a certain name with a certain extension, then no one else can register that specific name and extension. And it's also something we do for our clients here at Novograph. When you have a big trademark portfolio, it often happens that they also have a big domain name portfolio, and we are happy to maintain that as well. We do not really speak of a domain name right. It's more just like a possession, or as I said, an address on the internet that can be used. But it does happen that it conflicts with other IP rights, and especially trademarks. It can be very frustrating if someone has registered your trademark as a domain name, especially if you want to use it yourself for your own exploiting. But fortunately, there are some options to act against that. You can file a notice and takedown request with the web host or the registrar um, to block or acquire that domain name. You can file a uniform domain name dispute resolution policy with the official instances. The most familiar one is WIPO, the World Intellectual Property Organization, and they will then settle the dispute with regards to the domain name in question. And you can always go to court to appropriate the domain name or have it blocked. This is, of course, very costly, but then you also can claim damages if the infringement was heavy. To successfully file the UDRP or a notice of takedown request, 3 cumulative requirements must be met. The first one is that a domain name must be identical or confusingly similar to the registered trademark of the objector. Second one is that the registrant cannot have a legitimate interest in holding the domain name. For example, if you register your own last name as a domain name, then you have a legitimate interest because you are allowed to use your last name for exploiting a website. So if that happens to be a registered trademark, then the trademark owner cannot act against it. And the domain name must be registered or used in bad faith. You can think of, for example, when you are using the domain name to redirect users to your own website for your own gain, or if the domain name is being used for phishing or scamming purposes, then you can act against it as a trademark owner.
And next up, trademarks, a topic that is perhaps more well known with you. But before we jump in the legal aspects, maybe it's good to answer the question, what is a trademark? Why does it exist? Well, first of all, it has an origin function, so the public knows where specific goods or services originate from, and of course an identification function so that when people have purchased certain goods or acquired certain services, that they may identify the same or other goods or services after their experience with the previous goods and services. And of course, for companies, it has a important communication, advertisement, and investment function to the public, and well, also the goodwill function. From a legal point of view, it is an exclusive right and an absolute right, which means that it only comes to the holder, which is registered in a trademark register, and it is also an absolute right, which means you can prohibit third parties to use your trademark. And for trademark to be registered, you need to meet certain requirements. And one of the most important ones is distinctiveness, which means that a trademark is capable of distinguishing the goods or services of one undertaking from those of other undertakings. And secondly, it should be represented in a matter that is clear and precise. So trademarks or signs which are too complex cannot be registered as a trademark because the public should easily recognize the trademark. And please note that for characteristics such as shape, color, and sound, some trademark exclusion grounds are applicable. So if you do decide to use these signs as a trademark or wish to register such, please seek professional advice. And the most important requirement is the distinctiveness of the trademark. And the question must be answered if the relevant public is able to distinguish the marked goods and services as belonging to a specific undertaking as opposed to goods and services originating from other undertakings. And the relevant criteria to assess this is the goods and services in relation to the sign, and the relevant public in relation to these goods and services, and the perception of the sign. So think of Apple for electronic goods. That is distinctive because it does not say anything about electronic goods. But if you wish to sell apples or fruit under the trademark or under the sign Apple, that will not be possible because it's generic and descriptive, and it should be available to the public and all other companies to describe their goods, which are apples or fruit. So keep in mind, descriptive or generic signs are not distinctive and cannot be registered as a trademark. Fantasy trademarks work best, fantasy names, and also think of when you do want to have some suggestiveness there in there, that's also good. But if it's purely descriptive or generic, it's not registrable. And even if there's some distinctiveness in the sign, but it's almost fully descriptive or generic, and you can register it, you have a registration in hand, well, please be advised that it will give you only a limited scope of protection. And what we advise our clients is that when you do wish to maintain such a non-distinctive sign or logo, is to add distinctive elements to that non-distinctive element to still obtain a trademark registration. However, you will only obtain protection for the combined elements and not the specific elements and the descriptive element as such. And more about distinctiveness, a trademark can also lose its distinctiveness and ultimately be cancelled. So if you're not careful and your trademark becomes generic for the products or services for which you have registered it, it can be cancelled by third parties. And this happens most when there is conflation of trademark and product names for new products. So think of the air fryer, which is a trademark which was owned by Philips. Or think of spa, which is in Europe widely used as a generic name for water and not as the trademark. On the other hand, you can also acquire distinctiveness for non-distinctive signs and still have it registered in the registry and also obtain trademark rights from it. Think of booking.com for booking accommodations on holidays. So booking is quite descriptive and .com is very generic. But still, when they applied for the trademark, they were able to prove that the public still can distinguish their services from other companies. So still they obtained a trademark right and registration. There are many kinds of trademarks. So there are marks for goods, for example, Apple, as mentioned before, or Coca-Cola. There are marks for services, such as FedEx for shipment services, or JP Morgan Chase for banking or investment services. There are also a combination of the two goods and services for example, supermarkets, which also offer their own line brand. And there's also a difference between individual marks, which is purely meant for distinguishes goods and services, and certification and collective marks. And certification marks are meant to certify certain goods and services, so to speak. They reach a certain standard. And you also need to submit or file a regulation that go with it. And for collective marks, it's to show that your company or is part of a collective which also holds a certain standard. And well, trademarks can be formed by any sign. And the most well-known are word marks, word device marks, which are a combination of the word and the device mark in itself. Packaging, of course, slogans, which we'll be talking about later on, color marks, such as the purple one for chocolate, which is Milka, and there are also non-traditional trademarks, such as sound marks for jingles, multimedia marks, and hologram marks, but these are still not being used very widely, but maybe in the future.
Yes, and how do you obtain a trademark right? In general, there are two ways of obtaining trademark rights, namely by using it or by registering it. In most countries, you're obligated to register your trademark to obtain the trademark right. In some countries, like the United States or India, it is also possible by just using your trademark to obtain certain rights from it. But the registration provides a much clearer and stronger right, so we would always advise to register your trademark when it is possible. As Noe mentioned, the distinctiveness is required to obtain a trademark right and to obtain a registration. And you also have to keep in mind older trademark registrations, as they may form an objection if they are confusingly similar to your trademark. Before applying your trademark registration, it's important to determine the goods and services and the countries of interest. This way you will also determine the scope of protection of your trademark, as well as where your trademark may clash with older trademark registrations and rights. Therefore, it is also very important to conduct a clearance search before using or registering your trademark to see whether the mark is available and registrable. This is something we do regularly for our clients. We go through the trademark registers of interest, and with our expertise, we will look at all the potential conflicting trademark registrations and advise whether or not we should proceed with this trademark. Because if there are too many objections on the road, then we may have to decide to pull the plug, and this can prevent a conflict, and then also it can prevent many costs and time in that way. Then, when all the preparatory work is done and the trademark is hopefully available and registrable, you file the trademark application with the authority, with the register of interest. And especially with the classification of the goods and services, the authorities may be very strict in which is accepted. This must be very precise and clear what you list as the goods and services. So it is advised to use your trademark attorney while doing this, because they probably know what is accepted and what is not by the authorities. Then the authorities will examine the trademark application on absolute grounds, so mainly whether or not the trademark is distinctive enough or not. In some countries, they also examine on older trademark rights on the relative grounds, and they can refuse your trademark on the basis that not an older trademark exists. Fortunately, that's not the case in the UK or in the Benelux or in the European Union. So there, third parties may object your trademark application in the opposition period after the publication of it, and then they can object to your trademark application if they have older trademark rights. If no objections were made or they were overcome, you will receive your registration certificate, which is valid for 10 years in most countries. And if you are seeking protection in multiple jurisdictions at once, then it may be advisable to file an international registration or an European Union registration, because then you will get more protection for less money. After registering your trademark, it is important that you are going to use your trademark. With the other IP rights, it was not obligated that you use your certain invention or copyright your work, but with trademark that is a thing, because we want to combat unfair monopolization of a certain word or logo. And in most countries, you have to use your trademark 5 years after the registration date. And what is then normal use that can maintain your trademark right? It must be real and genuine use. So the use must have a commercial purpose and be aimed at gaining or maintaining a market share. So the use may not be just symbolic or just for preservation purposes. And in some countries, it is also mandatory to file a declaration of use after a certain period after the registration. This is the case in the United States, in Argentina, and the Philippines. And you also have to file evidence of use along with the declaration. And if you do not do so, or you do not do this properly, then you can lose your trademark rights right there and then. And to maintain your trademark right, you can also renew your trademark after the 10-year registration period. And here does the trademark right also differ from the other IP rights, because you can renew your trademark right indefinitely, which means that you can have a perpetual trademark right. So what can you do with your trademark right? Well, you can prohibit third parties in case they are using an identical sign for identical goods or services, counterfeit products, and you can also prohibit use of an identical or similar sign for identical or similar services if confusion on the part of the public arises. That means that if the marks are similar to a certain degree, and the public, the consumer, is in confusion of the origin of the goods, and they may think that both trademarks are from the same company, and yeah, they don't know where it comes from, then there's confusion, and the older trademark owner can act against the newer trademark. And in case your trademark enjoys a certain reputation, your scope of protection becomes more extensive, because then you have the possibility to act against similar or identical trademarks that are being used for other goods and services. For example, Coca-Cola is, of course, for soft drinks and for sodas, but they can also act against the use of Coca-Cola for example, guitars, because they have such a large reputation that if you will use that trademark for other goods or services, you are free riding on a reputation of that trademark, and that is not allowed. And how do we detect trademark infringement? We have certain monitoring tools to detect trademark infringement. The first one is our watching tool. With our watching tool, we can monitor all trademark applications all over the world. And if they are close to the registered trademarks of our clients, then we will inform them about it, and then we will decide whether or not to act against it. And we also use online brand protection, in which we monitor online use of the trademark. And if we find something we don't like, then we can also decide to act against it. And how do we do that? We send cease and desist letters to the alleged infringers, in which we kindly request them to withdraw their trademark application, or to stop and declare that they will definitely stop the infringing use. We can file opposition or cancellation proceedings to prevent the other party from obtaining or maintaining a trademark right. And if those options do not work, it's also possible to go into litigation and to obtain an injunction through the court. Luckily, this does not happen very often, and we are able to settle most of our cases amicably with the other party. The duration of trademarks registration is 10 years, as I said before, and you can renew it every 10 years, and if you do not, then it will, of course, lapse. You can voluntarily withdraw your trademark registration. You can have a non-use cancellation filed against your trademark registration by a third party, and if you cannot prove the use, you will also lose your trademark right. And if the third party files cancellation action on the basis of their older trademark rights and it is successful, then you will also lose your trademark right.
Then next up, slogans, which is in itself, as mentioned before, no real intellectual property rights, but still a topic of interest, and therefore some explanation on it. We'll know that slogans can be protected by copyright and trademark law, and well, just note that the usual requirements apply. But for trademark registration, just keep in mind that the slogan must have distinctive character, and that the public does not normally recognize a slogan as a trademark. And it is because most of the times they are just normal sentences, or they are very long. So that's why the public do not really recognize a slogan as a trademark normally. However, there are of course possibilities to still register a slogan as a trademark if you meet this distinctive character, and that is a tip from us to you to do so is to use your brand name in the slogan to obtain this distinctive character, and maybe in combination with a witticism or a double layer in the slogan to obtain this distinctive character. And a great example of such a slogan is "Have a break, have a Kit Kat." As you see, the trademark KitKat is mentioned within the slogan, and it has a double layer. Have a break, have a KitKat, because, well, of course, you need to break a KitKat. And moreover, it is short and therefore more recognizable for the public. And last but not least, trade names, and we will make a comparison to trademarks. It's good to know that trade name are national law instead of, for example, Benelux legislation for trademarks or European legislation for trademarks. And the trade name protects the name under which the business is conducted, while trademark protects signs or to distinguish goods or services which are marketed under that name. And, well, no registration requirement or possibility for a trade name protection is also good to understand. It only arises by use, and it only goes as far as where the trade name is well known. In addition, it's also good to mention that a trade name can only refer to a name and not a logo or other signs, which is the case for trademarks. And while there's also a very different test of likelihood of confusion, because as said, this is only for where the trade name is well known, and of course only for the name. And a last difference with a trademark is that a descriptive sign is not protectable under trademark law, but it is possible under trademark by trade name law. My apologies, but again, the scope of protection is limited.
Yes, there was quite a lot of information in a short period of time. So we have created an overview for you with all the IP rights we discussed today. I will not go into detail because we have just discussed it, but the PowerPoint presentation and the slides will be shared with you online, so you can have a look at it whenever you want. We did want to end the presentation with some trademark tips. So the first one is that you have to keep legal distinctive character in mind when creating your trademark. Made-up names work the best. Try to avoid names that describe your product or your service. When you enter the market with a new product, introduce a new trademark name, but also a product name to keep distinctive character for your trademark and to prevent dilution of your trademark. When you try to protect your slogan, it is wise to use your brand name in it, have a double layer in it, or use a witness in your slogan. In that way, it becomes more distinctive and you have more chance of protecting it. Before using and registering your trademark, conduct availability and registrability searches. In that way, you will prevent conflicts, and that will save a lot of time and money. Also important to enforce your rights if necessary to maintain your distinctive character in commerce. If you do not do so, anyone can use your trademark name, and then, of course, the value of your trademark will become less and less. And obtain advice from your trademark attorney before registering your trademark to maximize your trademark potential, prevent potential conflicts, and smoothen the registration process. That was it from us for today. I will have a look at if there were any questions. I do not see any. If you are triggered by us, by this presentation today on intellectual property, you can stay up to date on the important developments by subscribing to our monthly IP newsletter, or follow us on LinkedIn, where you also will be updated on the newest developments with regards to intellectual property. And if you would have any last questions, please contact us through our email. The last slide is not working again. Well, you can, of course, always contact us at our email with info@novograph.com, or you can telephone us if you are looking for advice. And we are always happy to help you, of course.
So thank you very much for your attention, and I think there is a question there. Oh, yes, right. If there are any questions, you can also mention them in the chat function. I see. Someone raised their hand. So if you have another question, please mention it in the chat function. And well, if you have any additional question, do not hesitate to reach out to us, even by email at info@novagraph.com. Thank you very much.
Enjoy the rest of your day.